Okay, Linda, so I have the document up. Here it is, number 17613. And why don't you walk me through what we're seeing here? What's happening here? We obviously have your name up here, Linda Xiao, the petitioner, versus, is that Sang Qin Wang?
Yes, correct.
And okay, so walk me through what I'm seeing here, because I see docket date of October 24th, 17, and you saying this was altered on 10/25/17 to be June 8th, then changed back to late November of 2017.
And there was a decision date. May I please explain?
Yes, please, go ahead.
Okay, that was when the filing date was a mailing date, October 17, 2017, and the docket date was the date the U.S. Clerk's office actually docketed the case into the file of the Supreme Court. On the next day, the next morning, the decision date was changed to June 8, 2017. I was following up with the docketing clerk. I want to find out, I want to chase to make sure the petition was properly filed. When I called in the morning of October 25th, this is what the docketing clerk told me. He said, Supervising Clerk Jeff Atkins told him to change the date to be June 8, 2017, and stated that it should not be Linda Xiao versus Chan Wang. It should be another case, Linda Xiao versus McManus Faulkner. And he said to the docketing clerk that the name of James McManus as well as Michael Reedy should not be posted anywhere. And I told him that was wrong. The decision day was April 28th. It's not June 8th, 2017. And he said, talk to my supervisor. I cannot handle it. So that was what happened. So it looks like that Jeff Atkins, without anyone noting him, he could not, it's impossible for him to go to the desk of the docketing clerk asking to change the decision date. And it was changed back after I filed papers with the court. And 1 month later, during the Thanksgiving time, it was changed back to April 28, 2017. Throughout the petition, I never mentioned that June 8, 2017 to be the decision date. So this is someone behind that told Jeff Atkins. This proves the existence of conspiracy. And then if we go down to, let me see, November 17, 2017.
Okay, all right, hold on. All right, here.
Right. So that is, this is regarding the defiling of Amicus Curiae motion. If you scroll to the second page, that will be more clear.
Okay.
The second page. You can see that at the middle part of second page, this entry was altered on December 18, 2017. The December 9, 2017, it took about 2 weeks for the U.S. Clerk's office to docket entry of receipt of Amicus Curiae motion of mothers of lost children. And then 10 days later, on December 18, 2017, they altered the docket to be this way.
Okay, wait. So on December 18th, they altered the docket to read like this?
To be not accepted. So that means they defile. They defile it.
Oh, I see what you're talking about right here.
It was defile, but
not accepted for filing.
Right.
And if you look up here on November 17th, motion to leave for to file amicus brief was here on the 17th. It takes them whatever amount of time. Gotcha.
17 until December 9, so that means 22 days. So they did not docket it took 22 days, but 22 days includes the mailing time, so it should be 20 days. So they waited 20 days to eventually docket it. If you scroll to page 3, would you please kindly scroll to page 3?
Yeah.
So if you take a look at page 3, that was printed on at the left upper corner. This docket was printed on December 18, 2017. And if you see the entry, December 9, it's accepted, it's filed. Amicus, mothers of lost children, Amicus brief of mothers of lost children, it was filed. And the file, the e-file was posted there. At that time, if you click at the bottom, a line lower than that, mothers for a motion for leave to file.
Yes.
You will see the e-filing document, the complete document. You will see that. So this was altered. The same entry was altered. If you scroll back to page 2, you will see that now it's changed. It was changed, removed, altered to be not accepted for filing for December 9. The same entry.
Okay, so let me go back here. So here it is. We're looking at December 18th, 2017. It clearly shows that Amicus brief of mothers of lost children is submitted right here on December 9th. And then you go over here, December 9th, not accepted for filing. Now, I guess my question is, when they decide not to accept something for filing, don't they have to tell you a reason, like you didn't sign it, or it was past the due date or something?
No reason.
No, but I'm telling you, I mean, what I'm asking you is, normally when the courts do not accept a filing, they have to give you a reason. In this case, they don't give you a reason, right?
They just asked Chris Katzenbach attorney to refile. Later, they say we will defile because it was improperly filed.
Gotcha.
So they didn't say why was it not properly filed.
Right.
We are to defile it, and they say, oh, you probably need to separate, with some very weird excuse, you need to separate the motion from the brief, and the motion contains only 1 page, and no one did that. No one did that throughout the practice of the law. It's always combined in one pleading, and they want to separate it, and there was no legal basis. So eventually they post again. It's identical document, and they post the document. They posted it, and then they corrected the December 9th entry to make it the correct date of the November 17th. But they did not. The clerks has a duty to post any activity of refiling. They didn't do it. So right now on this website, the U.S. Supreme Court, if you go into this case, if you click on the November 17, 2017 file, if you click open, you will see the file name was 2017-12-19. It was refiled on December 19. And it was under my threats while I sent an email to the clerk, Donald Baker, that this is a violation of the penal code. This is a crime. And you have no judicial immunity. And I gave him the case law that he just cannot do it. And then this was put back. Yep. So this shows the irregularity. Yeah. And if you see the page 2 right now, for February, now it's pending for hearing for tomorrow, February 2nd, 2018 petition for rehearing, and February 6th, 2018 request for recusal. It is not named a request for recusal. It's named renewed request for recusal, but they did not put renewed. And also the date, they should have put February the 2nd, 2018. But the supervising clerk, Jeff Atkins, who's in charge of this, he refused to put February 2nd, 2018. Supposedly, they were mailed simultaneously. only one mail, simultaneously.
Mhm.
How come they put the 2 dates? It's very fishy. But they probably try to say, oh, it's not timely. You should file the same time. Probably that's their argument. But the clerk knowingly put on the wrong date. I sent objection to Jeff Atkins. He refused to correct. So Jeff Atkins apparently was someone directed him to do something on this docketing of 17613, or otherwise this kind of irregularities never happened.
Right.
In the U.S. Supreme Court. It did happen frequently in my cases, in the underlying case, which include alteration of docket. So this make connection regarding the conflict of interest. I truly believe Jeff Atkins are directed by American Inns of Court or by James McManus to do these things. His alteration of a docket in the beginning on October 25th, 2017, shows his connection with James McManus and Michael Reedy, who are very active attorneys and so-called leading attorneys of American Inns of Court. And you may recall that my comments regarding Jeff Atkins allowing another of his colleague, supervising clerk Jordan Bickell, Bickell, Jordan, Jordan. He allowed him in September to step into Jeff Atkins' authority to bring a clerk named Donald Baker to disallow filing in 17-82. So disallowed the filing of Amicus Curiae motion of mothers of lost children. So that is to tell you their violation of First Amendment and 14th Amendment of the Constitution. The U.S. Clerk's Office violated Federal Rules of Civil Procedure Rule 5D4. It violated Federal Rules of Appellate Procedure Rule 45B1 and 3, which spells out the duty of the clerk to maintain the dockets and records. They violated the Federal Rules of Civil Procedure Rule 79, which required the clerk's office to keep the record of a civil docket. They failed to enter into the docket that December 2020. They put back this docket. They put back the Amicus Curiae motion into this docket. They altered the docket on December 9. They failed to correctly docketing the receipt in the first place and delayed by 20 or 21 days. And docketing of December 9, 2017, and later changed on December 18, 2017. So this is the proof that God helped me to say. The page 3 I printed under the instruction of God, and then within an hour it was changed. So it was within an hour, December 18, 2017, when I printed it, the third page, the docket changed for the entry of December 9, 2017. This is irregular and violation of their duty, and this constitutes a conspiracy to disrupt the basic function of the U.S. Clerk's Office, which violates 18 U.S.C. Section 371 and justify impeachment of Jeff Atkins. Thank you.
All right. Well, this is very interesting. It's just amazing the amount of evidence that you have. Now, let me ask you this, Linda. Is this something that the FBI would get involved with? Who would be the enforcement, the legal enforcement arm that would get involved in something like this?
That should be U.S. Department of Justice as well as FBI, yes. And regarding impeachment, that will be the U.S. House of Representatives. So I truly hope the audience can encourage their representative in the area to issue article of impeachment. to impeach Jeff Atkins, impeach Jordan Bickell, and impeach the 8 justices. The Chief Justice of the United States have a statutory duty to oversee the correct function of the clerk's office.
Gotcha. All right. So the FBI would look into something like this, where maybe somebody is disrupting justice or meddling with court services or processes.